Hey, good morning to everyone in Business Law 1. I'm going to put up, I think, a fairly modest video, summary thoughts on Chapter 7, which deals with capacity and also competency, very related principles. Because if somebody you're dealing with doesn't have capacity or competency, the contract may be void or voidable. Most circumstances in most jurisdictions actually voidable. And going back to Chapter 5, we have those definitional terms. What a voidable contract means is either one party or both parties have the right to either treat it as unenforceable if they haven't yet performed, or they have the power to disaffirm, basically unravel the contractual obligations to be put in a position they were in before they entered into the contract because of some kind of condition like this, capacity or competency. We're going to learn there's others later on, like duress, fraud, and undue influence in mistaken material fact. They might allow one of the parties to treat the contract, or both, as voidable. Void means the contract was never any good. Some jurisdictions treat contracts with incompetent people, for example, to be void. Most don't. Most treat it as voidable, meaning at the election of the person with the incapacity or lacking of competence, if the court does find that that condition existed at the time of contracting, will allow the party to undo it. But it's enforceable up until that stage. And why that's important to note, one of the major concepts we're going to go for is called the minor's rule or the infant's rule. People under the age of 18 can enter into a valid contract. A lot of people think they can't. Yes, they can, but it's voidable. So that's why you're thinking, well, you can't, because you really have the risk as the adult to having the contract undone and you basically being harmed as a result of that. That's true. So you're right in your gut sense that children can't enter into a valid contract, but you're wrong in terms of the legal analysis if you think that way. Minors can enter into a valid contract. However, they are generally voidable. Why do I say generally? Like most things in law, there are a lot of major exceptions. The one dealing with minors, and we're going to start with that right there, this usually relates to what we call capacity. In almost every jurisdiction, Massachusetts included, a person under the age of 18 isn't considered an adult. And because we don't consider them adult, we're saying that they have certain protections that society wants to put into place. So one of them is called this thing called the infancy rule or the minor's rule. Minors can't be held to a binding contract if they're under the age of 18, if they so wish to opt out of it. Even later on, even much later on, if they entered into the contract at the age of 12, will allow that 12-year-old many years later, up until the age of 18, to disaffirm and basically undo the contractual obligation and get back whatever they given the other party. Of course, they have to return what they received, but what if what they received was damaged or diminished or destroyed? This is what people get wrong in the test every single time. Everyone says, well, they would have to pay the deterioration value or the fair use value or for the destructive, the item that was destroyed. No, they don't. They have no legal obligation to reimburse the adult for any deterioration or loss at all, unless when they entered into the contract, they did so with fraudulent intent. That's going to be very difficult to prove. Now, what's the major exception to this very important rule? I hope you grasp that. People under the age of 18, when they enter into a contract, have the right to have it undone up until the age of 18, because once they hit 18 and they fail to act on this right, the contract is deemed ratified by silence. So if I dealt with a 17-year-old, and I just actually got a political button in the mail today. You can see the background. I collect political buttons. They're not one of my favorites. I just had it in my hand a minute ago. It doesn't matter. But here's one. So this little political button. It's Eisenhower, and Richard Nixon was the vice president. I don't know how much it cost, but I bought. Now, if I was dealing with some young person who wanted to, was into the political button collecting like I am, and they said, hey, Jim, I'll buy that button for you for $5. And I said, sure, you get yourself a deal. And the person's 16 years of age. That's a valid contract. However, it's subject to being disaffirmed or repudiated. Well, what if it was like I agreed right now over the phone, or let's assume we did it in writing. I wrote it up. They both signed it, but we're going to execute the deal next week. They're going to come up with the $5. I'm going to deliver it to them. And they decide not to go forward. Could I sue them No, I can't, because it's an unenforceable contract, because it's voidable. They'll just opt to say, I wish not to be bound. I am a minor. And they'd be out of it. But what if I sold it to them and they decided, because they thought it was a cool pen, I don't know, they're pretending to be in a play from the 1950s and they've got an Ike Eisenhower button on, and they scratch it up and they dent it and it gets all wrecked. And then they start thinking about it. I go, geez, I wish I never bought that button. That was stupid. And I'm really broke right now. I'm going to call Corman up and say, I want my money back. Can they get it back? Yes, they can. And what if I get it back? I said, geez, now it's not worth anything because you bent over the tab and it's all scratched up. You should give me $4 as a result of the damage you've done to the button. Well, maybe they should, but there's no legal requirement to do so. Minors have the power to avoid the contract. I hope that's set in. I'll give you another example, a real life example. My buddy, who's an attorney too, he and I were driving down the road, and he sees his son, they're both named Mike, and the son's named Mikey. Now he's a full-grown adult, but this is years ago. And he sees this kid, and he goes, what the heck is Mikey? Oh, I'm going to kill him when I get home. And I'm like, well, what's he doing? He's just riding his bike down the road. It was like a summertime thing. It wasn't like he's skipping school or something. And he goes, oh, I think he bought this bike. That's what he's talking about. He goes, well, he worked all summer long, cutting lawns in the area, had like a little sideline thing going on. He probably saved up a few $1,000s. Did really well. He was really hustling, basically, for like a full-time deal. And we had a bike shop in the neighborhood that was very expensive. The community, I think the person opened a bike shop thought they could charge a lot more because of the neighborhood we lived in. And they opened up a bike shop. And when the kid says, hey, I want to buy this bicycle, and it was almost like, I don't know, 30 to 40% higher at this local bike shop here in town. He said if you went to Worcester, you could get the same exact bike for a lot less. And he was telling us something, we'll go get it next week. Like a lot of young people, I think the time Mikey was 15, Mikey decided to go behind his father's back because he had the cash. It was his money. He went down and bought the bike. So his father, being so angry, went home, made him get the bike, which he had for about a week. Probably had a little bit of wear and tear, but very minor. But let's assume it was kind of beat up. There's some mud on it. It was no longer going to be a new bike, even if returned. It was ridden through the woods. It was one of those kind of bikes, mountain bikes, I guess you call it. And he rode it hard, and that wasn't damaged, but it was definitely not pristine. It wasn't brand new. So when my buddy Mike, the attorney, brought it down to the store, he demanded to get his son's money back, and the guy points to a sign up behind the thing. It's all sales final. Well, that might be your policy, but the law trumps policy. The law is superior to policy of a store. And so he said to the guy, he says, look, my son's 15. He entered into the contract with you. He has a right to rescind it, and he would like his money back, all of it. I think it was $800. The guy says, no, I'll sales final. And so my buddy throws out the, well, I'm an attorney. Of course, he was dressed in street clothes at the time, and he was kind of a rough-looking guy. I didn't believe he was an attorney, so he showed him a business card. He goes, I still don't believe you. But the guy had an attorney friend, the owner of this bike store. So he calls his attorney friend, and you see him talking for about 5 minutes on the phone. He comes storming in the room, takes out $500 or $800 out of the register, and gives it back to Mike, and then gives it back to his son. Of course, he gets back the bike with some minor scratches and dirt on it. He can't sell it as a new bike anymore. It's his loss, and a lot of people are going to say, "Well, that's really unfair." Is it? Think about who we're trying to protect. We're trying to protect minors who don't usually have the intellectual maturity and wherewithal to not get ripped off. And who are we also trying to be? And somebody say, well, what about the poor store owners in these circumstances, or the merchants, or the people dealing with minors? They're the freaking adults. They should know better, one. And two, now because you've taken this class, you know to protect yourself. How do you deal safely with minors? I'd love to sell you the bike. Have your mom or dad come down and you can buy it. And that's how you do it. And how you know this rule is, Corman's not so full of crap when he's talking about, or the book, if you read the book. I hope you're reading the book. Think about, I don't watch it anymore, but when my kids were younger, it seemed like the television was on before school started, right after school was on, a channel called Nickelodeon. I don't know if it's still around, probably is. Well, I used to like SpongeBob when it was first up, but SpongeBob was on, and iCarly, and Drake and Josh. It disturbs me. I remember the names of these shows. But the commercials were almost always geared to young people, for kids. At-home cotton candy maker. I don't know. Flashlights that show certain images. I don't know what it. Kids stuff. And guess what they said every time at the end of the ads? You must be 18 years of age or older, and then call this number and buy this wonderful product, or have your parent call. Why are they doing that? Because it's the law? No. They want to protect themselves because if the kid buys it, 17, 16, 15, they could take it, use the product, beat the living hell out of it, maybe even get it destroyed, and would they still be entitled to get their money back prior to their 18th birthday? Yes, provided they didn't enter the contract with fraud. Most kids don't know anything about this rule at all, and if they did, they're exceptional. And and the reason why the rule doesn't come up in that many circumstances is most parents aren't going to help out their kid after the kid goes and destroys, some product they bought. And says, geez, I know a little bit about business law, and I know we can get our money back for Junior here because he went and destroyed or wrecked this product he had bought. And even though it's beyond the warranty, he's still a minor, and he's the one that actually went and bought it. Let's go bring the goods back, what's left of them, and get your money back. That would actually work unless it was about the intent. But most parents are going to do. They're going to tell the kid to be responsible. They're the ones that wreck the gear. I always think about this back when GameStop was really big. I couldn't stand going into the one that was in my local community because it was a really small store. And it was always packed when some big new game was coming out or console was coming out. So I'd go there with my 4 kids, and they'd have their, whatever birthday money or holiday money, whatever it was. And I said, geez, I'll tell you what, you guys go in and you guys go buy your stuff. And they would come out. And that was back before you could download the games directly from the internet. So they come out with, I think it was CD-ROMs, and they would load them into the different formats and the cartridges and the little PS things, whatever they had. And they would sometimes wreck them and scratch them because they weren't careful on loading or unloading, or they'd leave them on the floor and the cat would get a hold of them. And the kids would get upset. So, it's not working. It's whatever, skipping at something, or it's I didn't buy the insurance. I can't return it. It's beyond the return date. I say, hey, Ken, you went in, you were, 15 years old when you bought it. You can return it. He goes, no, it says no. Look, it says right here. I said, yeah, I know it says it. But if you go back and demand your money back, they may not give it to you. But if we sued them in a court of law, would the court of law mandate that GameStop would give them the money back? Yes. But practically speaking, chances are very few lawsuits are going to occur. And most of the time, the adults are the ones buying certainly the higher end items. So how does a business protect itself when it's dealing with a minor? Have your parents come in. And I used to show a video because of copyright rules from Chapter 3. I don't have access to that video, and I can't find it through a link in a form. It's an old video. It's really corny, but it was pretty good. In this aspect, they show this young lady coming in and goes, I bought my boyfriend, a motorcycle on a credit. It took out a credit loan, a big Harley Davidson, a fat boy for my boyfriend. And he went out and he totaled it the next day. He's okay, but the bike is just a real mess. And in the little, theatrical little, drama they try to put together, the attorney goes, how old are you? She goes, I'm 17. I'll be 18 in 2 months. And when you bought the motorcycle, were you 17? Yes. And how old your boyfriend? 17. He goes, well, I can tell you what we can do. We're going to write a letter to the motorcycle thing, and we're going to demand your money back. Where's the motorcycle? He goes, oh, it's in my boyfriend's backyard in a big pile. They would actually have to find a way to get what's left of that motorcycle back to the Harley Davidson dealership. And what would be given back to the 17-year-old girl? Any money she put down, plus the obligation to pay any further payments to the motorcycle would be null and void. I know most of you are shocked, but think about it. What business isn't savvy enough to have taken a course like this, or have enough knowledge, or have a lawyer or somebody that knows enough about business planning to avoid, especially if it's higher end items, dealing with minors and contracting? Is very, very dangerous. The next issue that comes up is, are there some exceptions to the rule? Yeah, one is fraud. I already told about that. So if a child lies about their age, God, my daughter's boy, well, now they're married and he's 25, but when they were first dating, he was like 17 and my daughter was 16. And I remember he came over and he had like a full ZZ Top kind of beard and stuff. And I'm like, I thought he was in his 20s, mid 20s, if not 30 then, because he just looked old. Actually, ironically, he looks younger now after he shaved. But the point is what if he lied to me and he had a fake ID and all that stuff, that he was over the age of 18? He'd be bound to the contract because minors are liable for torts, and one of the torts is basically fraud, and that's the type of, so they'd be liable for that. Are they liable under any other circumstance? Yeah, it's contract for necessities, and the book does a great job of saying it's not really clear always what a necessity is, but the fundamentals are things like making sure there's a standard of living that's sustainable, like food, shelter, clothing, educational costs, or things related to educational expenditures are usually considered necessities. Now, there's not case law on it yet, but in the future, somebody might say in rural areas, maybe a cell phone or internet access, which costs money, might be a necessity. So if it's a minor contracting for it through Comcast or Charter or whatever the cable system is, a court might rule that having those kinds of products might be a necessity. Medical care is a necessity. That would also be something where the minor would have to pay for, because it's to keep you going and alive. It's considered to be part of a status or a standard of living requirement that the minor would have to pay for. The other is when minors are in the regular course of business, and occasionally it does happen. 16 or 17-year-old, or just on the eve of 18, might start some kind of business. I always think of landscaping somewhere, because my father, who's long since been dead, but he used to always admire one of his closest friends' sons started a landscaping business. I don't know, like 14 or 15, just mowing lawns in the neighborhood. And needless to say, it took off. And now he owns a major company that has, like, I don't even want to say the name of it because I might get it wrong, one, but two, I don't even know if he has a business interest anymore, but it's one of these chains. I mean, he started it up very early on. But while he was 15, 16, and 17, because he was in the regular course of business contracting with homeowners and businesses to do lawns and shrubs and all that kind of stuff, then it got more advanced with actually landscape design. Those contracts would be enforceable against the minor, because the minor is engaging in an adult activity in the regular course and scope of a business enterprise. We raise them up, we create a legal fiction, and we're going to treat them like an adult under those circumstances. It's pretty narrow, it doesn't come up that much, but it's good to know. So contracts that can't be avoided, necessities, business contracts. Yeah, it says some states make certain contracts, like student loans, medical care. Those usually are necessities anyways, but sometimes the point is that sometimes there's other statutory ones that might nullify the concept over minors' contracts being unenforceable or subject to avoidance. Disaffirmance, we told that. And again, on disaffirmance, what does the minor have to do? Return what they have, if anything at all, that's left. So I think of cell phones. My kid, I used to always buy insurance for my kid, all my kids, but my 21-year-old was just over here a minute ago, and he was notorious when he got his first phone. I don't know, 16 or 17, his first phone. It wouldn't be a week before that. I don't know how he did it. Like the screen would be cracked or somehow fall in the ocean. I don't know how it's just unbelievable. I wish he could do that for glasses. Now he wears contacts, so I guess it's not that big a deal. But his glasses were broken every day. Phone was broken every day, and if it wasn't for insurance, it would be a nightmare. But think about it. If he bought it, well, it was me that bought the phone for him. But if he bought it, I gave him the money, and he went into the Verizon store, the Apple store, whatever, and bought the goods, and he damaged them, could he return it and get a new one without any cost? In spite of the store, I mean, I know you're dealing with some clerk at the store, and they're going to say, "No, see you later." You don't threaten them with a baseball bat and say the law is you have to. No, you go through legal process. You sue them, and that's what Chapter 1, 2, and 3 we're building up to. Is there's procedures to do it. You can write a small claim, it'd be a slam dunk. But kids usually don't know enough. How do you deal safely with minors? Have their parent be the main contracting party. Minors torts, I don't know why it's in the book, but it is about the fraud. Minors are responsible for negligent action or other torts. We talked about, I think it's in Chapter 3, the intentional torts and the classic ones of being negligence, but also the tort of fraud, lying about your age. I'm going to hold them to an adult standard, and I'm going to make that contract enforceable. Now, mentally incompetent people. Mentally incompetent people might be because of lack of mental wherewithal from birth. They might have a congenital defect, so they don't have enough mental wherewithal to basically understand the nature of the bargain that they've entered into. That contract is, if they've never had the ability and never will, that contract is void. We want to protect people with mental limitations. Now, some people have mental impairments that are, I was going to say seasonal, that sounds terrible, but they ebb and flow with wellness. People in the early stages of dementia, for example, they get elderly, they get older, they might have a form of dementia that's starting or that's in play, but they have good days and bad days. If they enter the contract in a period of wellness or lucidity, they're thinking clearly enough to understand the nature of the obligations they're entering into. That's a fully binding contract. What about this? They enter in a contract where they're they've lost their ability to voluntarily understand the meaning and obligations under the contract. That contract is voidable. Why is it voidable? Because what happens if the person, when they're feeble-minded or incompetent because of this terrible disease ravaging their brain, what happens if during a period of time of wellness they find out they bought something, and geez, I bought a electric lawnmower, I did, oh wow, I love it, it's great. The contract shouldn't automatically be void. We just want to protect the victim when the victim needs to be protected. And if they're well again because of medication or just a period of wellness and they want to ratify the obligation they entered into, they can. And the same is true as if during a period of wellness they find out they've done something when they were unstable or unfit, but they don't take any action. That's deemed ratified by silence. You can't just sit on your rights. Like, my friend always busts me because I bought a stuffed mink at an auction. And he always tells the story that I was really intoxicated. I got intoxicated after I bought it. While I was buying it, I was totally sane. But what if I did buy it during a period of insanity through the inducement of alcohol or drugs? That's the same concept, and we'll get into that a little bit more. But say I buy it when I'm not competent because maybe I'm suffering from dementia or I'm mentally ill and I don't have the ability to understand the nature of the consequences of the act I'm entering into. That contract becomes, again, in most jurisdictions, voidable. So if I'm well the next day because I'm sobered up or I'm off the drugs or because of the medication, my mental clarity comes back and I realize I bought a stuffed mink, what can I do? It's not automatically void. I can either disaffirm the contract, get my money back if I can prove I was incompetent at the time, or the alternative is also true. I can look at it and say, I can't believe I scored this beautiful stuffed mink when I was incompetent last night, and therefore the contract would be ratified and no longer subject to disaffirmance. So mentally incompetent people, obviously if you're in business or even if you're not in business, you're just casually selling something, if you think there's something not quite right with the person you're dealing with in terms of their mental understanding and wellness, ask to deal with somebody on behalf of that person, a ward, a guardian, a family friend, because you're just uncomfortable that they may not be well enough to understand the nature of the obligation you're entering into. This always brings up, for live class, people like to debate and get into this thing about incompetency based upon the voluntary ingestion of drugs or alcohol. This is unpopular in the court. So if you say, hey, I should really get out of this contractual obligation because when I entered into it last night, I was drinking, 10 Scorpion Bowls over at, the Chinese restaurant in town, and I was so plastered, I didn't know I entered into an agreement. That's basically the standard. When it comes to alcohol or drugs and to try to get out of the agreement, you have to really be so impaired that you didn't know the nature of the voluntary agreement you were entering into. You really have to almost be in a blacked out situation. The courts don't like it. Juries don't like it because you voluntarily ingested these alcoholic beverages or drugs. And so I sometimes put a test question out there like, well, what if it was something where you weren't so intoxicated that you didn't know what you were doing, but you wouldn't have done it but for drinking those 3 drinks? That contract's fully enforceable because you still had the mental wherewithal to know what you were entering into. You did it voluntarily. You knew the consequences of it. You might be filled with regret the next day, but you never lost capacity and competency during the negotiations and at the time of the meeting of the minds. And that's why there's a show called Mad Men. I never watched it. I guess it was one of these miniseries type shows. But back in the day, it was very common for people to try to do business dealings over a liquid lunch, a 3-martini lunch. You're the seller of certain products or services or goods. The other person is a potential buyer. You meet, you take them out to dinner, you ply them with alcohol. You don't get them so drunk that they're incapacitated, but you loosen them up so you can convince them a little more easily, perhaps, that they should enter in a contractual agreement with you. Those contracts are generally binding. You have to be so intoxicated, so under the influence of drugs, that you don't have the ability to voluntarily assent to the mutual meeting of the minds. And it's a tough one. It's a real tough one because I don't think it's very popular with courts. Now this one, the book, I don't know, mentions convicts. I think they're talking about convicts at the time they're serving a prison sentence. But generally speaking, just because someone's been convicted of a crime, I don't care if it's a felony or a misdemeanor, you're not going to bar them from entering a valid contract in the future. Otherwise, they're condemned for life or never getting a job. A job is an employment contract. And so I don't like that section of the book. But sometimes I think most jurisdictions, while a person is in an incarcerated status, often lose their ability to voluntarily enter into a valid contract because they lose certain fundamental rights that are almost inalienable to other people. And one of them is entering into contracts. But just because you've been convicted of a crime, you can enter into any other contract anybody else. If we take away people's contractual rights, how are they going to function within society? You know, you've done your time, you've done your penance, you've gotten your punishment. It's time to allow people to engage in life again. And a big part of life is entering into contracts. So that's pretty much it. Hey, I kept it under 30 minutes, much better than I thought I would do. And don't be afraid to reach out and ask questions. I'm just trying to summarize stuff and touch on stuff that maybe wasn't as clear in the book. I think the book does a really good job on Chapter 7, which is capacity and competency. I think I went over pretty clear, but never ever forget that a minor has, in many circumstances, the right to disaffirm a contract, even if the goods they have been worn out, damaged, or maybe even destroyed, and they have no obligation to pay any kind of depreciation or loss of value to the other party. Otherwise, be well.